the matter, Lord, for my Lord kind consideration. Lord, this is the matter in respect of the Public Service Commission, my Lord, recruitment for the junior engineers. Now, your Lordship had made the matter CAV. Now, my Lord, it appears, my Lord, that your Lordship had recorded, your Lordship had given a detailed judgment, not an order, not a judgment. But, my Lord, some points had been missed out. I have made a one-page note. I have given a written submission.
Yes, we have already
yes,
given. Yes.
But, my Lord, these points, my Lord, that for my Lord's kind convenience, that the vacancies which were arising, where from it will be obtained, I have made a one-page note. Now, if your Lordship, my Lord, permits me,
if you have given it to the other side, we will.
No, I had spoken. My learned junior had given an intimation to the other side.
So if you give it to him, he can give us.
Yes,
if you have given it to him, then he can give us.
Very well, my Lord.
Just ask him to get a receiving on and
Okay. My Lord, my Lord, this is my fault.
No, give it, please give it.
My Lord, I will be handing it over.
He has given written notes, perhaps.
Yes.
Yes.
But some.
All right.
My Lord, my other side.
Give her a copy.
I have given a copy.
All right. Give it.
Yes.
Place it in the file.
One judgment has also been referred to. I am handing over.
This is not something which was not argued.
Not argued.
Then I will not consider. Only what was argued I will consider.
This point which I have taken, this was argued.
Yes.
This was argued. But this judgment, my Lord.
Then we are sorry, we will not consider because it was not argued in their presence and we will not consider.
The particular proposition which has been.
Yes, we'll take that into consideration. Yes, because we have noted all the judgments that you relied upon.
Yes. Miller, I tender my unqualified apology.
No need for apology. Please.
No, Miller, it's my fault. My fault.
Judgment reserve at 28-4 ka.
My Lord, it's a mentioning application for review application.
Or?
Review application.
Take it after the holidays.
Yes, sir, item number 1.
My Lord had fixed the matter at 2 p.m. today and tomorrow.
Actually, that day it could not be taken up because perhaps the bench was not available. They informed me yesterday. So I asked them to put it under the heading to be mentioned so we can fix it for consideration.
Whichever date, my Lord.
You please give an agreed date the other side now. It can't be done in the next week.
1 week. 1 week after the vacation. My Lord, 1 week after the vacation, my Lord.
Yes, Supriyo. 1 week after the vacation, 2 days, 2 p.m. we want to continue for 2 days. Yes, just see which dates are available. Rely on any written notes you want to give. Can we request that you give it before the argument?
My Lord, we'll give a written note.
Yes.
A written note ready. We've given, my Lord, we have. My Lord, we've already, my Lord, I believe, my Lord, given, my Lord, a list of dates, my Lord. which my lord.
Yes, that we remember. We are saying if there are any written submissions which you want,
That be easier, my lord, we can move, my
we
lord.
can do it
Which
quicker.
your
That's why.
lordship did in the other matter. my lord.
Yes, yes,
We can move fast.
yes. Okay.
Because otherwise your lordships in any event take copious notes, my lord.
No, we do that, but we are all humans. We are humans. We may.
Yes.
And our memory is, we rely on our memory.
So I don't think so.
Let's see. Yes.
He'll come with a preliminary
your
note, my lord, in that case.
Your lordship is fixing it at 2 p.m. like my lord.
Yes. That will be better so we can
Yes.
conclude it in 2 days. Yes.
Pleasure.
Obliged. Grateful.
Number 2.
Here,
Eight.
Eight.
Can be done. Please wait
but
till
it will be on Monday because what I have learned yesterday from Justice Urijit Banerjee's division bench that from Monday onwards there will be a panel. But I had a matter of bail in connection with appeal. Yesterday the matter was taken up and it was the observation of Justice Banerjee that from Monday onwards there will be a panel of fresh advocates. All right. Monday. Great.
This is my application, madam. Madam, remember Mr. Kaur was leading me in this matter, madam.
Your Lordship had directed the private respondents to bring instructions whether they are ready to waive their duty, my lord. This is a matter of promotion, my lord, where an interim order granting stay was passed stating that they will be in temporary.
The implement order is.
We are
from
working in
page
the promotional post,
104.
but we have not been confirmed. Because of non-confirmation, we are not getting the annual increments with the corresponding dearness allowance and other allowances. But as of today, we are already at a loss. No, we are losing as of today. Now, there are 3 sets of writ petitions. In respect of 2 sets of writ petitions, persons similarly situated and promoted, they are getting all benefits like the holders of promotional posts. Except this batch of promotees.
their cases have been decided finally.
No. Same.
Where is that matter?
Those are before the honorable single
One
bench.
matter is listed today.
Yes.
First
That is-
matter, there are actually 4 matters now.
That is listed
Every year they take an suitability test. I challenge it.
And some of the writ petitioners get promoted to the higher ranks and they become respondents.
In this matter, I got an interim order.
But only in
But
this matter, next 3 matter he has not. And subsequently,
Only in this
all
matter
the
there
writ
is-
petitions
This
which has
is the
been
third
filed,
matter. This
which
is
has been
possibly the third matter.
filed, my lord, the petitioner has been.
I don't remember anything. Please let me.
My lord, kindly come to page 104, my lord. That is the order
There is
implement,
a
my
writ
lord.
petition which is being heard as regards a selection process or a promotional process to a selection rank.
Selection grade.
Selection, not grade, but it's a rank of assistant chief engineer, which is the next highest rank from in the hierarchy, the topmost level. But the question posed by my learned friend's client is, why should there be more marks in interview vis-a-vis the other factors to be reckoned for the purpose of this promotional exercise? But this is now challenge. There are 3 successive writ petitions filed in 4 writ petitions filed in respect of 4.
And you are the beneficiary of the exercise.
Yes.
In one of them.
And not in 3 of the processes, some of the writ petitioners themselves got promoted to the next higher rank following the same process which is under challenge. So they became respondents in the
That
success.
cannot operate against him.
No, he's an association.
They have not withdrawn their names.
No, even if those persons, all of them are like that.
Not
Who have
all.
already got promotion.
Not all.
So
Well,
those who have
what
not
they-
got, they will still remain.
Yes.
What they are doing, my lord.
Who are the
from the
petitioners?
Just let us understand.
From
Yes.
the
The
initial names, they are
association-
picking up one person and
The
giving
association, an office bearer of the association, and 2 or 3 persons who are really affected, they file writ petitions every year. So that in course of deliberation or in course of hearing of the writ petition, the Honorable Court wanted to ease out things by saying, you come up with a suggestion how it can be done. It's a question of only 15% weightage to be given in the
I disagree
in the
with this.
suitability. Very well. Let it be decided by the RIT court, the bench concerned. In this process, not it's one of the appeals. In one of the matters, an
So
appeal
what
has-
this honorable single judge held, which is before us?
Refusing to
Well,
confirm.
we wanted to
Refusing-
modify the order, my
No,
lord.
modification is just the term which is being used.
No, it is
They
not,
want
my
to
lord, it is
vacate-
my
They
application.
want to,
bullet.
they
My lord,
wanted to
kindly
vacate the
my lord,
order
kind-
after 1 year.
Not
No,
we had
yes.
been promoted to
After-
the
after-
higher rank.
They
As
did not challenge it at that point of
we
time.
had been
That
promoted
doesn't
to
bar
the,
me, my lord. My lord, kindly,
And the
my lord,
person who
kindly
was,
come to.
Yes, we understood everything.
person who was,
We
person,
understood everything.
Well, the
Wonderful.
person-
All of you speak at the same time. We are understanding everything.
we had been promoted to the higher rank, but retained as probationers. Unless we are confirmed in service, not we.
So you have come up.
No, it's the appeal by the the company.
We
Who,
have,
who
we have
finds
come.
difficulty in carrying on with the process because the next higher rank has fallen vacant.
Oh.
Not the feeder grade, see, unless not everybody comes within the zone of consideration for the purpose of filling up the topmost rank, not there is an administrative
So
difficulty.
after assistant chief engineer, there is a number one rank.
Number one rank. So not there has to be a zone of consideration in the feeder grade. This feeder grade is not settled as of today. Therefore, there are certain posts in the higher rank which are yet to be filled up. That's an administrative difficulty which has probably prompted the company to file an appeal from the order by which our promotion was not allowed to be confirmed. But it's on one hand we stand to lose by
So when is the matter fixed for
today
consideration?
not one of the matters is appearing before the honorable single judge.
Then let's see what happens.
because in any case, either of the parties will come before your lordship, because
That is different. That is different.
But only,
Perhaps that's why we fixed it today. Now we remember. We were told that it is to be taken up today.
Your lordships would probably wanted to have our views
Meantime, we
communicated
have
to the
wanted you
court.
to find out whether
But as of today, we are standing to lose. So nothing more which we can probably own up.
the difficulty is that we cannot, one of the promotional process has stuck. The whole organization has stuck.
they
But I will, if
have
my lord, allow,
conducted subsequent promotion.
sir, I mean, if my lord, and you have
So তুমি
challenged,
ভুল করতে-
if my lord may allow me, I will just show 2 pages, my lord. One is of the order of Justice Mantha, which has been passed in 22nd of December 2023, wherein the interim order has passed, and the order which we have challenged. Only 2 pages, my lord.
let us see.
And I will kindly come, my lord, to page number 47. That is the order they passed in on 22nd of December 2023. My lord, will kindly come to page 49 at paragraph 10. The last portion. May I read with your lordship?
Yes.
Now, my lord, will kindly come to can 2, that is my modification application. I will only show the prayers to your lordship, my lord, what we have pleaded, that is at page 42, para A and B, and my lord will kindly see paragraph 15 on the same page, wherein we have stated what is the present condition.
43, where's the prayer?
42, my lord, 42, page 42, internal page 16. Para A, confirm the service in the post of the additional chief engineer of the incumbents. Has your lordship got it? We are more concerned in respect of prayer B, when that is B, the next paragraph. And my lord, kindly please to peruse paragraph 15 at the same page, my lord. The present condition, my lord, we have tried to explain. Now, my lord, will kindly come to the order impugned, starting from
Yes.
kindly come to the impugned order, my lord, which starts from page 104. The 105, my lord, will kindly come the type portion by filing this application. Mr. Cord, learned senior advocate appearing for WBACTCL submits that WBACTCL is facing difficulty in promoting the concerned eligible candidates. It has further been submitted that unless the candidates currently holding the promoted post pursuant to the interim order are regularized, they cannot be considered for the next promotional post. On the basis of these difficulties, the prayers A and B of this application has been placed. I am of the view that allowing the prayers would amount to final disposal of the writ petition without adjudication on merit. In view of the foregoing, this writ petition should be decided expeditiously. Let this matter such and such. But we are,
We're just discussing the same thing. It would amount to giving a finality to the
we
whole
will
thing.
press prayer B, manner. We are not pressing prayer A. Manner. Kindly peruse, my lord, once more, if your lordship may kindly allow me to come to page 43, my lord. That is the prayers. My lord,
B cannot precede A.
we are not, we will not press for the timing, only prayer
Sir,
B, my lord.
A is inherent in B. Don't say we are not pressing for A. Unless they are confirmed how they can be promoted. There's a
They have already been promoted subject to when the
correct. So therefore, let it be. You proceed with whatever you want
the
to do.
difficulty is that the whole promotional process has got
So
started.
therefore, you know that they cannot be promoted. So unless A is allowed, you cannot proceed to B. And that would amount to deciding the issue finally. Then what will remain for the petitioners? If they have already got the promotion, everything, it remains pending, then what will remain? It is being taken up. You go and contest the matter. Nothing will remain.
No, I will only request let this matter be pending until and unless the writ petition is decided, manner.
Why? What is the fun in keeping it pending when the writ petition is being considered? Heard the learned advocate.
That 4 IPA for the petitioner. That this is an application for restoration. That if your lordship kindly takes up the restoration application when I have served it to the office of the GP. On 8th May,
Not today.
around 8th May, the matter was dismissed or devolved. And on 11th May, we have filed the application.
Oh.
On Monday. That not today means Monday or tomorrow. Five.
I am for the respondent number 1.
Your Lordship, in this matter, Mr. Syed Nurul Arifin is appearing. Your Lordship, he is engaged in another court. Your Lordship, I am praying for not today. Your
You are for
Lordship.
respondent,
Contempt applicant, Your Lordship.
applicant.
Applicant.
Respondent contempt.
You have filed a compliance report.
Yes, I have filed the affidavit in opposition.
Not today.
Grateful to you.
Six.
Madam, I am appealing for the petition. Madam, I am appearing for the petitioner. Now, this is an application for early hearing of the writ petition which was filed in the year 2012. And a direction for filing affidavits was given in 2014 only. All the affidavits have been completed. Since thereafter, the hearing did not take place. In the meantime, the petition number 1 is a registered association of the state veterinarians. But in Annexure C, at page 39, I have given a list of about 200 veterinary doctors engaged in state veterinarian service. But who have either retired or
Not today. We were informed that perhaps state advocates will be appearing from Monday.
that is the
Let us see.
But I shall give another notice on Monday.
Why, to whom you will give the notice?
That is the whole problem. But that is why I will.
Let us see, it will come on Monday. If there is some development, then you.
As you-
7.
For the petition of led by Mrs. Ramalda. Also, I am for the petition led by Mrs. Ramalda. My earlier location, my lord, direction to specific instruction has been filed by the state.
Not today, Monday.
Wait.
I am for Union of India.
Hmm? For? This appeal arises out of an order passed by the Honorable Single Judge. What did you, you are the writ court, you are the writ petitioner. What you approach the court for? Yeah. You are held guilty in the inquiry. So you challenge the order of the disciplinary authority and the appellate authorities or the Honorable Single Judge. Obviously, therefore you challenge both. So then the Honorable Single Judge has rejected your writ petition. This appeal arises out of that. Let us see the order. Please give.
What are the page 65? Page 65.
Yes, what is wrong with the order?
That is again here. This is the clause at the time of just that, but make party and has already granted and his judges
What has been granted? What has been granted?
uh, yes already when he was absent at the full court, his absent has been uh, exonerated.
No, you have admitted to that charge.
No. I am not accepting.
You have,
After that,
that is the first charge.
after that,
That is the first charge.
that charge had already been thereafter exonerated.
How it can be exonerated? You have admitted, then it is exonerated. Admitted means established. Admitted does not mean exonerated. Come to the inquiry report.
59 property. Up to date, the offense was committed on 13/1994 regarding this. Kaspal Singh has asked the apology in front of the HC Diagram,
Sir, this
Ikejina and Parminder Singh. Because Kaspal Singh incident has been reported in diary number 53 dated 22/1992 at High Court.
what is the date of this document?
What is the date?
Date of this document.
Document submitted.
Undated document. Old matter means nothing is to be given.
195. When he was removed from service, before that particular assistant commander.
Where is the date? Where is the date? Where is,
Which is respondent number 6 here.
where is the date? Where is the date? Then how do we know that it's a genuine document?
Right. According to 22nd February 1990, just been mentioned
That is not what we are asking you. We are asking you what is the date of that document. Yes. You filed any written statement of defense? Where is that?
Page 42 of that.
Page 42. Huh? 42 is not your written statement.
Response stated the inquiry officer as well as the disciplinary officer.
Again, we are asking you, did you file a written statement of defense?
Defense.
So you did not file any written statement.
I am not. Because the stated that charge number 2, especially the charge number 2. Then every allegation is totally false.
No, charge number 1. You have admitted to charge number 1.
Admitted charge number 1.
Yes.
I am not.
Correct. That's what we are saying.
relying on a judgment, I refer to that. I am submitting before your lordship.
Yes, so what is wrong then? First charge you have admitted. Second charge, you say that the inquiry officer has examined 4 witnesses. The victim has been examined. Victim has been examined. Medical documents has been examined. Then what else? What else is to be examined?
Cross-examination, they stated that they are not seen.
Correct, correct. That we have seen. That we
On
have.
the basis of assumption, harsh punishment can be imposed.
All right. So that is your submission. What else? What else?
Harsh punishment.
Yes. What else?
Chapter 10 of 1969 rules, procedure for penalty has been prescribed. 34 days with the nature of penalties, where the penalties have been classified in 2 categories, namely major and minor penalty. Removal of service, that is the case. Removal of service has been classified as major penalties under sub-rule 2 of Rule 34. Impose major penalties, procedure has been envisaged under Rule 36 of 1965 rules. First question is that, madam, all the statements
yes.
that is the evidence chief, the chief of the all the witnesses, PW1, PW2,
Yesterday we have seen.
PW4, all the statements are
Yesterday we have seen that CIS.
all the contradicted, they are inconsistent in nature. As such, when the controversy has allowed perseverance and matter, all the witnesses that in G4, they hold that they are not seen the particular incident and the particular incident.
34-2, yes. Yes.
Scope of judicial review is very limited, I know. But question is that court can interfere with the punishment only if it finds the same is shocking, disappropriate, disproportionate to the charges put. Suppose logically the charge has already been put, but question is removal from service, the harsh punishment, disproportionate, shockingly disproportionate. So many judgments are there. One judgment I have referred to the lordship court, particular matter. The quantum of punishment has been considered by the Supreme Court in category of judgment, and it has been held that the punishment awarded is disproportionate to the charge of misconduct, the arbitrary, and thus would violate the mandate of Article 14 of the Constitution. Ranjit Kumar case, Ranjit Thakur and Union of India Order, AIR 1987 Supreme Court. A lot of particular judgments. This is basically the harsh judgment. AIR 1990 Supreme Court. Volume. Judicial review. Judicial review. Generally speaking, it's not directed against the decision. Right. But it's directed against the decision-making process. A decision-making process are challenging. Decision-making process is totally wrong. Each and every step of the inquiry officer to appellate authority are nullified appears to justice. All the steps. In all the BW2, BW3, BW4, they stated they have not seen this particular incident. Once they see the helipad, once they see the delinquent Air Khan is standing on the helipad, on sitting on the bench, such and such, such and such. Even the doctor, most vital witness. Section 3 of the Evidence Act. They go.
Evidence Act will apply to a departmental proceeding. Yes.
Judicial review. Judicial review, generally speaking, it was directed against the decision, but is directed against the decision-making process. The question of punishment is within the jury. Questions of punishment, questions of choice and quantum of punishment, and discretion of the court martial. But sentence has to suit the offense and the offender. It should not be vindicated or unduly harsh. It should not be disproportionate to the offense as to stop of that offense. And among the itself conclusive evidence of the witness. You do not have the conclusive evidence. If the Air the respondent number 6 has Peter repeated, the key number 59 is the question of the officer to go to the criminal court. And Lolita Kumari's judgment, once the action has been, once complaint has been made, 154 CRPC clause 1. Yeah. Questions of bloodshed, questions of blood group, that means the questions of DNA. Only the circumstantial evidence. The judicial scope, though it is very much narrow and pedantic, but question is when it is shocking of concern, that should be considered. Only to lot down the post, only to lot down the post. They can. The doctrine of proportionality as part of the concept of judicial review to ensure that within on an asset which is otherwise within the exclusive province of the court, court martial, if the decision of the court given as to sentence is an outrage, defiance of logic, then the sentence should not be immune from the correction. Irrationality and perversity are recognized grounds of judicial review. Recognized by the statement. The entire facts that have been stated, giving the delinquent to submit all his reports to the disciplinary authority, giving the appellate authority, but they ignore. Lord, what is the actual quantum of punishment? The appropriate quantum of punishment to be awarded to a delinquent is a matter that primarily rests of the directions of the disciplinary authority. And authority sitting in appeal over any such order of punishment is by all means entitled to examine the issue regarding the quantum of punishment, in as much as it is entitled to examine whether the charge has been satisfactorily proved. Here the charge has not been satisfactory. It might submission. But when any such order is challenged before a service tribunal of the High Court to exercise the jurisdiction, discretion of the competent authority to determine and awarding punishment generally respected against except where the same is found to be outrageously disproportionate. The charge of misconduct. Here the misconduct has been charged. Removal from service. Giving post-retirement benefit, they did not provide to the applicant. Though the order has been passed in the first single judge on Dr. on first civil judge, first first appeal, first court, first trial, Dr. Manibhutto Sambhuddha Chakraborty. That punishment is excessive or disproportionate. The offense has to shock of conscience of the court and is unacceptable. Even the court should slow and deny react unto the interference. That's what the law on the subject is well settled by a series of decisions rendered by this court. The doctrine of proportionality. What is the doctrine of proportionality? Doctrine of proportionality as part of the concept of the judicial review. I must say, judicial review must interfere with this particular matter. Because a person has already been removed from service, dismissed from service, there is no previous incident or no previous charges against the particular appellant. They have charged with this very particular two charges. One, the roll call matters, and the other is which are liquidated to the year 6. The doctrine of proportionality as part of the concept of judicial review to ensure that even on the aspect which is otherwise within the exclusive province of court person. If the decision given to the sentence is an defiance of logic, then the quantum of sentence should not be new complex. It is something recognized on something. However, if the punishment imposed by the disciplinary authority of the appellate of the shocks the conscience of this court, then the court will appropriately move the relief either by directing the disciplinary of the appropriate authority to consider the penalty imposed or to submit the application if they make an acceptable and imposes appropriate punishment to persons reasons in support thereof. Also clear from the above judgment of this court. If the punishment imposed by the disciplinary authority is totally disappropriate conduct, proof given the delinquent officers, then the court will interpret. Punishment of removal on service. Kind of misconduct. Who takes the decision appears to grossly disappropriate.
Yes, that's all. Yes.
Now, kindly come to page 66, my lord, of the trial court, my lord. Page 66. My lord.
Yes.
After 4 or 5 lines, my lord, the second charge has been established at the departmental inquiry both by oral and as well as the documentary evidence. The person who received injury has deposed himself along with others, and from his evidence it appears that the petitioner had beaten him with belt, and as a result of this blood was coming out and he had to be taken to the hospital where he was admitted. This was the finding of the trial court, my lord. Again, my lord, with regard to the inquiry report, my lord, there has not been any lapse on the part of the inquiry officer in conducting the inquiry into the charges. The petitioner was given sufficient opportunity to cross-examine the witness, and it does not appear that there has been any error on the part of the inquiry officer in coming to the conclusion relating to the guilt of the petitioner. So now this is the second finding. Naturally, the disciplinary authority, considering the gravity of the charges and particularly keeping in the mind the discipline which is expected from a member of a discipline force, has passed an order which cannot be said to be disproportionate or too harsh for the offences committed by him. The grounds of rejection of the petitioner's appeals calls for no judicial interference. So both findings are here by the trial court. The inquiry was well by the inquiry officer, and no guilty was found there. So no judicial interference is required. And this is they have lost thrice, my lord. And so lordship see from the beginning, they're in their list of dates, my lord. First appellate court dismissed the appeal in 95. Thereafter, they filed a civil. Kindly come to page 2, my lord. Page 2, my lord. Serial number, after serial number 8, my lord. Petitioner dismissed from service. Thereafter, petitioner's appeal was dismissed by the appellate authority. The civil court of Gurdaspur dismissed the civil suit filed by the petitioner. Thereafter, Punjab and Haryana High Court dismissed the revisional application. Petitioner filed writ application in Punjab Haryana High Court with a direction to file revision application. Punjab Haryana High Court rejected the another revision application. Thereafter, they filed in Delhi High Court. Then Delhi High Court transferred the writ petition on territorial jurisdiction ground to Calcutta High Court.
All the aspects are.
Then Calcutta High Court dismissed the application. So
Where are those orders? Those orders.
Delhi High Court order.
This is the way. This is the way. When you were saying, was he saying anything? Please. Yes.
The Delhi High Court was only transferring to Calcutta High Court.
Where are these orders? It's not on record.
It is here, my lord. In Delhi High Court, I have seen. Delhi High Court page, page 60.
No, the other orders are not there.
Territorial jurisdiction court has transferred.
No, but the other orders you said
orders are not
there. So I don't know. You need not go into that.
But in paragraph, my lord, they have in their paragraph 23, 24
of the writ petition. Of the writ petition.
This appeal, they have mentioned this paragraph, page 20, 21.
20,
page, my lord, 20. Page 20, paragraph 24. That the petitioner is simple-minded person, doesn't know the service matter procedure, and on wrong legal advice filed a city civil court in Gurdaspur. They have mentioned this, my lord. In paragraph 28, they have mentioned about the Punjab and Haryana High Court.
Where is the Delhi High Court judgment?
High Court judgment, my lord, at page 60, man.
60.
60.
Yes. Yes, what do you have to say?
Eight lines on the bottom. 8 lines on the bottom. Small. Regarding statement of bill of death, is a doctor in which he stated that he has not seen any injury on the body. Yes, but at the time it was dark and it was dark 7:30 at 7:30 hour. And when PW4 reached the place of occurrence, he saw that it was to be bleeding from the hands of Johnson Sathata. After this, he has exhibited the numerous of the doctors in the hospital.
So he was bleeding. So what is the? Yes.
Statement one.
Anything else? Anything else? Heard the learned advocate. Not to. You are appearing. Call. Give the pipe. This is it.
He was here all morning. He was here. Beginning.
You have got the judgment.
I've got the judgments, Lordship.
That one or any other
I
judgment?
got the Jesus sale. So I've got other judgments. I've got one Justice Jyoti Prakash Mitra. That is a 6 judges bench of the Supreme Court, where the question of personal hearing had arisen, Lordship.
Personal and oral hearing.
Personal and oral. This was a personal hearing where Lordship. Lordships will kindly come to paragraph. This was under Article 217, sub-Article 3 of the Constitution of India. Lordship, the relevant portion for us starts from paragraph 26, Lordship. Lordship, the citation is 1971, Volume 1, SCC. SCC 396. Union of India versus Jyoti Prakash.
Yes, the Union of India.
Jesus Sales Corporation is more specific, Lordship. I produced that also, 1996.
This is not any proceeding under any rule.
Not under rule, Jesus Sales Corporation, yes, but the right of hearing, the oral hearing, Lordship, there also it is.
But here the apex court was considering a decision by an authority who is repository of such power at much higher level.
This is at a much higher level, Lordship. This is at a much higher level. But the principle laid down, Lordship, that it is not that, I mean, oral,
The
it
apex
has
court
to,
held he is not a
the
court.
question is
He is
whether
not
they
a
are,
court. He is
he
the
has to be apprised of all the evidence against him. That is the basic principle that is.
No, he is not disputing that. He does not say that nothing was given, anything was not given.
But
He is saying oral hearing.
oral
was not.
hearing, Lordship, then I am covered by Jesus Sales Corporation. Lordship comes to paragraph 5.
Yes,
This is very
surprising that I remembered that day. In fact, it is very much.
This is absolutely on the point, Lordship. It can't be opened up when the rule provides. And Lordship,
Yes. Any other
Lordship, Lordship, these are the two where oral hearing is not a must, Lordship. And Lordship, on the previous occasion, your Lordships had pointed out the tentative findings. Lordship, the decision was relied upon by my learned friend, the Love Nigam, decision of the Supreme Court, that is 2006, volume 9. Lordship, this decision was from on April 3rd, 2006. Lordship, the 2001 rules, Lordship, refer to sub-rule 3. The disciplinary authority shall forward or cause to be forwarded a copy of the report of the inquiry, if any, held by the disciplinary authority, or where the disciplinary authority is not the inquiring authority, is a copy of the report of the inquiring authority together with the reasons for disagreement, if any, and record its own findings on the articles of charge. So
Which rule?
Rule 36, sub-rule 21, 3. Therefore, Lordship, where it appeared that he's made up his mind, Lordship, that is what he was required to do. Thereafter, the Supreme Court, this was prior to the decision, thereafter the Supreme Court has laid down that it should be tentative.
In reference to the same rule.
Not the same rule,
It's in a
but
different
in the same circumstances, they should give their tentative findings. That was the Supreme Court's finding, but the decision relied upon by minority.
That Supreme Court decision also deals with a central paramilitary force.
This one doesn't deal with this particular decision doesn't deal with the paramilitary force. This was a no, this was CCS disciplinary of the ITI. It's not the paramilitary. But the rule here, Lordship, is rather specific to give his record its own findings. So therefore, that is what the rule was, and he has done exactly according to the rule. The first notice, sir. Every
36, 21, 2.
21, 3, Lord. 3. 3. Twenty-one, 2 and 3 actually. 2 is also applicable. But he has to give his findings on the charge. Therefore, he has done that. Lordship, the judgment of the single judge of the trial court, Lordship, had gone beyond the rules. There was no opportunity of filing a second show cause notice. It was not required. And in fact, this, the dissension was communicated to the petitioner. He had filed his representation. So the finding that there was neither any opportunity of hearing or that the court had confined itself to sub-rule 5 of Rule 36 and not 21, which was the rule applicable. The judgment refers to sub-rule 5 of Rule 36, but the actual rule should be ruled.
Which judgment refers to sub-rule 5?
Impugned judgment, Lordship. This judgment. inquiry was conducted in terms, but then and according to the trial court, it was not complied with. But that is not the case. And here it's
Judgment deals with 5.
yes, Lordship. Lordship, kindly come to page 143. Inquiry was conducted in provisions of Rule 36. Lordship, there's second paragraph. Lays out the rule. Rule 30, where the disciplinary authority itself inquires into any article. This was a question of the presiding officer, and he held that the presiding officer cannot, nobody can differ with the presiding officer because he is the representative of the disciplinary authority. Lordship, that is not, it cannot take a view. The finding of the court was very categorical that the disciplinary authority could not take a view different from what the presiding officer took. That was the categorical finding, which your lordships will find in page 144. That I humbly submit is absolutely contrary to Rule 36 sub.
Disciplinary authority was bound by what the presenting
Yes.
officer said. Any judgments you want to say?
Judgment, before that, my lord, I shall the disciplinary authorities findings.
That you have already, we have recorded. We just, what
No,
judge?
my lord, come to page 1 or 2 of the paper book. I say, my lord, the disciplinary authority has not gone into the inquiry report properly, and he has prepared his disagreement note without going through the inquiry report. Can you come to page 1 or 2 of the paper book? From 1 to 1 on 3, 1 on 4, disciplinary inquiry officer has categorically detailed in detail what are the evidences come.
What is that 114?
1 or 2, my paper book, my inquiry officer
114.
1 on 2, from 1 on 2, my lord. Inquiry officer's report.
No. What do you want to show? Why the inquiry officer?
I see, my lord, the disciplinary authority says that our inspector report has not been considered by the inquiry officer. That's why that is the disagreement. But kindly see here, all has been considered by the inquiry officer. So disagreement note has no footing to stand.
But that is exactly a completely different submission from what you made on the last day.
But that was only on the basis
You said that such a disagreement note was not sustainable as being in sufficient compliance with principles of natural justice.
But that is
now you are trying to raise an issue that
because,
factually it
my
is
lord,
not sustainable.
Because my lord,
How we can go into the factual aspect?
not factual aspect. You are also
asking
inquiry
us to
officer report, my lord.
Huh?
Inquiry officer report is not the factual aspect. Inquiry officer's report is not the factual aspect.
It is a factual aspect. All the factual findings are there in the inquiry officer's.
My lord, that factual aspect.
What else is a factual aspect?
What disciplinary authority said, that particular.
That is not your case. You have argued something different today. You are arguing something
When
different.
that is coming, my lord, I have to place all the cases. Your honor also goes to all the cases.
We have heard everything recorded, submission, fixed it for citing judgment. Now you are arguing a new point.
No, there is, my lord, because the disciplinary authority.
It's not the way. And both the points are mutually, they cannot be. How it can be? Once you are saying that it is not complying with the natural justice. Second, now you are saying that is not factually incorrect.
But disciplinary authority has not taken into consideration that. But he says,
We are not going to reappreciate.
no,
In a
I'm not
judicial
saying-
review, we are not going to
I'm
reappreciate.
never praying for reappraising evidence.
You are asking us to do
No,
that.
I am
To
praying-
going to see whether the disciplinary authority has
No, no,
considered everything
evidence
from the inquiry report.
evidence has been recorded by the inquiry officer.
Where you have said in your reply to the disagreement note. Where you have said in your reply to the disagreement note. Show it. Where you have taken this point.
No, my lord,
Then
when the disagreement note
where
came-
is the, you must have given a response
My lord.
to the opportunity when the opportunity was granted.
My lord.
Did you raise this issue? Every day you will come up with a new plea. Wonderful way of arguing a case.
Now, my lord, during hearing their claim, my
You
lord,
cannot do that, sir.
that since the
And if we
discipline,
take it up tomorrow, you come with another plea.
my lord, that is not
Wonderful.
only the, my lord,
Endless hearing of one case forever.
during the hearing, my lord, this point came.
Where have you taken this point? You can say if it was not considered only if you had taken the point. If you have not taken the point, where is the question of non-consideration? Show whether you have taken up this point. You cannot keep making out a new case every day. That's not the way to argue a case. Once everything issues have been settled, we have recorded the submissions, we have kept it for us giving citation. Now you want to argue something which you never raised anywhere.
Just coming out. My lord, come to page 117. Perhaps there is something.
This is the entire thing. It is like an appeal.
No, my lord,
We are not going to look
there
into
I have taken, my lord. There I have taken. The reasons, next page coming, I have taken all the points.
which page?
Page 118, my lord.
Yes.
1, 2, 3. The disciplinary authorities are in stating that the Mr. Jamshed along with others were one of the CICF Jawan for stealing coal by such and such. It is also erroneous that the said miscreant has identified their said constitutional argument, petition before my lord. That such observation is erroneous and more than erroneous. It is repeatedly emphasized that the concerned inspector had searched me and they could not find anyone with me.
We are not going to sit in appeal over these things. Please try to understand
This
the
is, my lord,
jurisdiction in which you are arguing a case.
this is the
We are not going to sit in
my
appeal.
lord, this is the
It
reply.
may be wrong. We don't know.
My lord, this
That's
is
not the scope of
my lord,
judicial
this
review.
is the reply against the disagreement note.
Yes. Why should we look into all this factual aspects in judicial review? We will not. The issue is a procedural illegality. You said that since it contains tentative findings, it suffers from procedural illegality. That is all. We are not going to sit in appeal over all these things, whether the decision was taken based on sufficient material or not. He has given you an opportunity. That
My
we are
lord,
not going to go into. Sorry.
my lord, okay, my lord, I'm coming to the judgment.
Yes.
One judgment of a coordinated bench, my lord. I filed yesterday. There, preliminary rule my learned is mentioning there has been discussed. Preliminary rules, my learned is today submitted. In their judgment, that is discussed by the coordinated division bench. That the rules are on.
3621.
That yesterday, my lord, I have placed with my lord 2 copies. The reported
Today you don't have it.
1 copy.
Huh?
1 copy I have. Yesterday I have given 2 copies.
One copy. How can we consider with one copy, sir?
We have submitted 2 copies, my lord.
You have given us already.
My lord,
In this case,
my lord.
So, yeah,
Yes.
this lordship, it's been given, he's given the judgment. If you
So that on the last day
That
you
is
have
already
given. We have already noted in the last, in the order.
That was the
That
High
we have
Court
noted in the order. You must have read the order,
That-
last day's order.
That is noted.
My lord, this has self.
See, now you are relying upon these judgments. The Honorable Single Judge finding is based on 36(5). It is submitted by the learned advocate for Union of India that it is not at the stage of 36(5). It is at the stage of 36(21), 2 and 3. And 2 and 3 sustains the course adopted by the disciplinary authority. That is her submission. Insofar as the requirement of oral hearing, she has relied upon the decision. Every statutory authority at every stage, when it says hearing, it cannot mean an oral hearing.
Not every state, my lord. Kindly visualize. When inquiry officer has given hearing to the respondent, he has come to a definite finding which is support of the petitioner that has been altered without oral hearing. My lord, that cannot be altered.
That is your, that we have
Well,
recorded.
Because I am making submission before law. You are seeing me, you are seeing my attitude, what are my case
Correct,
study.
correct.
That
That we have recorded. That we have already
that
recorded.
gives much importance, my lord.
That's why we are saying, so that every time, at every stage,
Not every stage. When the disciplinary authority is overturning the report of the inquiry officer, then only. Otherwise not.
otherwise there is a question of any hearing. So in every case, that means the appellate authority will have to, or disciplinary authority will have to rehear.
Not in every case.
When he has delegated the,
Not in every case, my lord.
when he has delegated the role of making an inquiry to the inquiry officer, then he will again rehear the matter. This is what you are saying.
Not in every case, my lord.
No, wherever he differs, whenever he differs.
He has to.
Yes.
The Supreme Court has said so.
Yes, so
Supreme
that
Court
we have seen Supreme Court.
Supreme Court said so.
That we have seen.
My lord.
Supreme
second, my
Court
lord,
has not said oral hearing. Can you point out in any
Opportunity-
decision
the
that it has said
opportunity-
oral hearing?
my lord, opportunity of hearing.
Can you point out that it has said oral hearing?
My lord, my respectful submit, my lord, subject to correction. Opportunity of hearing is different from opportunity of making representation.
You are re-arguing. You have already submitted this.
No, today I'm
No, you have submitted this on the last date. That once it says hearing, it means hearing. We have, therefore, I didn't remember very clearly, but that decision I had seen. It is directly on this point.
Jesus.
Hearing does not always mean oral hearing.
my lord, that my lord, Mr. Jails Sales Corporation is not applicable. That is distinguishable on the case. Then my lord, that was taxation case. And my lord, the appellate authority without hearing has given relief to him. He has reduced the deposit to 25%. Since he reduced the cost, the Supreme Court held there is no reasonable. There's what is the purpose for him?
Then where is this fact that because it has been reduced, it was not required? Show from which paragraph?
I'm pressing my lord.
Which paragraph this has been stated that because some relief has been granted, therefore oral hearing is not
Yeah,
required.
Karun Maila, kindly see, look at what.
Which paragraph, sir?
Just tell you, my lord. Just look.
So the outcome will determine whether there was a requirement of hearing or not.
Madam, come last paragraph, my lord. Here are the pages number one. Only I'm probably my lord. I bring you one copy to India. Kindly see in the present case, last paragraph, my lord. In the present case.
Paragraph 7, Lordship.
In the present case.
Lordship, paragraph 7.
In the present case, the appellant filed a response to the discretion of giving report only 25% amount, which had been imposed against him.
That is the quantum.
That is the
My lord,
quantum.
That is the quantum. That
That is the
25%
quantum.
is a reasonable amount.
That is why their opportunity of hearing given.
And you are reading into it. We are unable to see the Supreme Court saying anything like this. We don't know from where you are getting it.
But this,
Yes, this we are seeing. We are unable to find what you are saying. The court has said because it's 25%, it is reasonable.
my lord,
Not that because of that the hearing was rightly not given. How the outcome can determine the veracity of the procedure? The procedure is to be in accordance with law.
my lord, that is
irrespective of the
reasonable. Supreme Court that is says reasonable. So my lord, no hearing is required.
But we don't think any.
But in this text and statute, my lord, there is a provision of oral hearing.
Do you have any other judgment? Very well. Pass the order tomorrow.
But in the taxation tribunal, there is a
Of the parties.
statutory provision of
Number 12.
Final round for affidavit. Mr. Rothenkorn is leading this matter. He has not come to court today for personal difficulty. Kindly fix this matter after vacation.
As the after 22nd.
Number 13.
13, my lord, in this matter, I am led by Learned ASG, my lord. ASG has not come today, my lord.
Same order.
Which is Deep love. Number 14.
Respondent also.
Arising out of departmental proceeding. You are appearing.
Yes, Your Lordship. I am led by Mr. Bishwarup Bhattacharya.
Yes.
I'm praying for a Passover, Your Lordship.
Very well. Let us start. He will come.
Yes, 276 the review note order passed by the Honorable Single Bench, second volume.
To 73. You are appearing. Yes, we just went through the order, the Honorable Single Judge. What is your case? That malified aspect.
The procedure adopted by the inquiry officer is not known to law. No documents were proved, no documents, the procedure envisaged by your lordship's court as
That
well.
is not argued by you. You have only argued malified. You have not argued anything else.
True, but we are before the appellate court.
Not in a writ proceeding. Points which were not urged, how you can argue now?
The documents were admittedly in terms of the
Cannot-
judgment laid down by the Supreme Court.
At every stage, we cannot enlarge the scope of judicial review. The only issue raised and decided is issue of malified. You say that he has made some emotional observations which cast an aspersion on my bona fides or attribute malified to me. This shows the predisposition of the inquiry officer when there was no such charge. This is what you have said. There is no charge regarding fraudulent activity or any such thing. And then all the three stages, there is material, there is witness, there is evidence, and the nature of allegations.
The evidence that was produced, was not produced in a procedure known to law. Apart from anything else.
So what is that violation?
That, in my respectful submission,
What was not followed? The documents have to be given in a list of documents along with the charge memo. Charge memo is to contain the articles of charge, statement of imputation, misconduct, documents, and list of witnesses. At this stage, you do not allege any violation.
Since what has fallen, I am the whole judgment. May I most humbly request your lordship to kindly take it up tomorrow. I will come a little more,
It will come on Thursday as prayed.
And 16.
But for item number 15 to 20, I am for the petitioner, your lordship.
15 to 20.
Yes, ma'am. My lord, I'm praying for not this week. The advocate on record is under critical condition medically.
Why?
The advocate on record, she is under.
They are all connected matters.
Yes, my lord.
As prayed after the holidays.
After vacation, my lord.
2 weeks after the holidays.
Twenty-one.
Ask him to take it outside. Ask him to take it outside. Why is he making noise here? He's gone out of his mind or what? Courtroom or what is it? Yet for me to say something, you should be telling him.
Lordship, I'm behalf of the petitioner kindly not today.
Not today.
Yes, Lordship.
Why, madam? What is your problem?
Senior is not too well.
Not well. Let us see. Let's see the order last.
Lordship, after
Hmm?
after vacation.
Just wait. Give us 2 minutes, please. You are required to repaginate the records. It has been done.
The paper book, Your Lordship, or the petition, the entire petition.
You have done nothing after the last quarter and you want a time today. Last 5 years. Nothing. There was a direction to repaginate. Why have you not done that, sir?
So, Lordship, with regards to the direction regarding the pagination, we were not aware of that fact.
You are not aware. There is an order of the court. What more can we do than pass the order?
Lordship, kindly gives us some accommodation, Your
At
Lordship.
least undertake that exercise. That's what we are saying.
Then, Lordship, kindly pass an order regarding.
No, we'll not pass another order. You do it. We have already passed an order. There is an order already. Please see the order. See an order. The order is dated. It is dated 8/12/21. You are for the appellant. Why have you not repaginated? All of you are clueless. Please do that.
pagination in what Lordship under
Show him the order. Show him the order. Last order. Learned advocate for the appellant. Oh, there's no question of being sorry. These are basic practices. You go through the order sheet before you come to the court. What is the last order? At least that much you should see. Just check up. If anything is required, you do it in the meantime. Yes.
Then 24. Item number 24, my lord, Mr. Hon'ble Lahiri, senior advocate, is appearing in this matter. He is engaged in another court, my lord. But the matter pertains to, my lord, appointment of judicial officer in the West Bengal tribunal, my lord. State is the answering respondent, my lord. If your lordship may fix it after vacation, my lord, then, my lord, it can be heard properly, my lord.
Relates to appointment of a judicial officer.
One of the prayer is there.
Where is the, can you show us the prayer, please? Which page? Because perhaps the judicial officer's matters may not be listed before this page.
If page 23, my lord, B, my lord.
23B.
23 prayer B, my lord. To immediately certify and transcript produce all record forming basis of inaction in not filing up the vacant post of judicial members and administrative members in West Bengal State Administrative Tribunal, so that constitutional justice may be administered by setting aside or quashing the same. Thereafter, my lord, alternatively, I have prayed that on the OA 470 of 2019 may be heard on merit, my lord, upon consideration of prayer made therein, absence of any forum, my lord.
As prayed, list after the holiday. Third week. Third week. 25.
25 June. 25th June. March. 25.
No, we are appearing for the private respondents, added respondents.
There is none to represent the writ petitioner.
26.
This matter, Your Lordship, I am for the petitioner. Ganesh Sri and Murai Chakrabarti has not come to the court due to personal difficulty. I am praying for the not today only.
Hey, ask him to dust this. Clean it, bottom, top, everywhere. There's so much dust. Ask him to clean it. None appears for either of the parties.
1, 2, 5,
In item number 1 and 8, my lord, I am appearing. On the last day, Lordship might recall, my lord, we filed an independent appeal. There was some discussion about the settlement, my lord, relating to ECL. Some of the matters Lordship had already, my lords have disposed of. So far as these two matters are concerned, on the last day, I made a submission, my lord, that my client instruction, my lord, is to, my lord, press my independent appeal, which is for interest, my lord. And Lordship was kind enough, my lord, to fix the matter, my lord, today. So, my lord, I would humbly pray before your Lordships, my lord, to take up this matter, my lord. It's a very short point, my lord.
First case.
Item 1 and 8, my lord.
What about the other matters? What is the issue now in the other matters?
But I am only in 1 and 8, my lord.
No, in the other matters also there is an issue of interest, or it is all, it is who appears in the other matters?
Item number 2, 3, 4. I am on the appellate. In respect of my lord, our independent appeal in respect of interest.
So 1, 2, 3, 4. And what about 5?
I am not appellate. My lord, so far as my lord, item number 6, 7, and 8, and 9.
You are appearing.
6, 7 are for the respondent's writ petition. And item number 8 are for the appellant where my senior learned friend is leading. And item number 9 are for the respondent number 9 of the writ. And
Remaining cases? Who is 8 and 2? All right, that's not writ petitioner. Who is representing the writ petitioner in the other cases?
My lord, item number 12 and 14, my lord, I appear for the appellant, and where in item number 13 I appear for the respondent.
Currently, we are trying to find out who appears for, whether all the writ petitioners are represented or not.
No, my lord, item number 12, 13 and 14, my lord, writ petition, Mr. Partho Ghosh is appearing, my lord.
That's why we are trying to see whether everybody is here or not.
Yes.
We don't want to proceed piecemeal. Issue
Yes.
is only of interest.
Yes, my lord.
So in all the cases, we want that you make a submission on one day, we will finally decide the matter. Not that 2 cases today and 3 cases tomorrow. That we don't want to.
My lord, if Lordship permits, my lord, then one thing I can submit, my lord, with regard to my matter 1 and 8, my lord, ECL, my lord, they wanted to pay, my lord. That was the initial order passed by your Lordship. Of course, there was a rider to that order that if the parties agree. Now, my lord, subsequently, my lord, I found, my lord, a notification which says, my lord, even if I press for my appeal independently and separately for interest, so far as the principal amount is concerned, the notification says, my lord, ECL has to pay.
That they will pay anyway. Once they have agreed, they will pay.
But unless court directs, my lord, possibly the amount has not come to my client.
Lordship,
Maybe not. Maybe not. We'll see. We'll decide that. See, there is no dispute on the amount admissible now in view of the fair stand taken by them. Whether you will get an interest or not, we don't know. But we don't want to go about it piecemeal. You make some argument, the other counsel comes, he makes a third argument, then everything goes haywire. So therefore, it is best that everyone should press their issue of interest together, so that all aspects can be considered. Whatever argument is to be advanced by everyone. You see, if the other parties are not represented, then we can't do it today. If you know Mr. Das, you know who appear in the other case.
My lord, in some matters, my lord.
Are they already appearing in those matters? Notice has been issued.
Yes, my lord. In all the matters on the last occasion.
Somebody or
also,
the
my
other
lord.
is representing them in all the matters.
Yes, my lord. Now, Mr. Ghosh is in 3 matters, my lord, I know. So 1 to 8, your lordship has already got it. And the remaining matters, my lord, one matter, Mr. Kaur was.
But my matter is all the matters are by one single job relying on map. Map only is one.
You are trying to push on merits, we can understand, but we have already observed what we have to observe. We will not go piecemeal. It is most undesirable tomorrow if somebody comes in 13 and makes an argument which you have not made, then what happens? Please try to understand what we are saying.
My lord, item number 12, 13 and 14, my lord, actually what we submitted, so which reached a consensus, my lord, where Mr. Ghosh also agreed, my lord, that without interest, we are ready to pay the
Item number 10 to
yes,
my
12,
lord,
13 and 14, my lord.
I think, my lord, in common order on consent, it may be disposed of, my lord, here and now.
Which
Yes,
one?
yes,
Well,
my
item
lord.
10 to 14.
10 to 14,
10,
you are
my lord.
appearing.
Yes.
That we are looking for you only.
Oh, well, I
Yes.
did not notice, my lord.
In 10,
10, my
Yes.
lord.
Bush is appellant. In 11, ECL is appellant. Now, my lord, ECL is able to pay MMCC without.
Yes.
If he agrees, then.
Yes, yes, my lord. 10 to, my lord,
10 to 14.
Yes, your lordships may pass the common order that the single judge order may be complied with without any interest. That will be, my lord, on consent, your lordships may pass.
Yes, my lord, on consent that may be passed only, my lord. In 12 and 13, there are two applications for condonation of delay, my lord. It's only, my lord, technical thing, my lord. Two applications for condonation of delay are pending in 12 and 13, my lord. And one thing, my lord, only to clarify, my lord, in 12 and 13, my lord, in 12, my lord, it's 12 and 13, my lord, it's a appeal against the two appeals against the common order, my lord, same order, my lord. In 12, my lord, the original writ petitioner died. She has been replaced by her
Lordship
daughter, my lord.
already substituted with your
Yes,
lordship's order,
she
my
has
lord,
been,
already
yes, yes,
substituted,
she has
so
been
there is no
substituted
dispute.
by her daughter.
So
daughter,
actually
so
we
my
are,
lord,
we are,
whatever
we
MMCC is
actually,
to be paid,
actually
to
we
be,
are dealing with 3 cases in which a consent order can be passed.
My lord.
yes, my lord.
3 cases,
No,
but 4
10
case numbers.
Yes, 10 to 14.
Yes, 3
Yes.
cases, but 4 case numbers.
Yes, because counter appeal has been filed. So lordship may pass.
There is a condonation application in 12 and 13.
Yes, my lord. Yes, my lord. 12 and 13,
That
there
may
are
be, my lord,
condemnation
condoned.
applications.
Please give 12 and 13, file of 12 and 13.
এরকম অর্ডারে দেওয়া আছে
একসঙ্গে কনসিডার
1 to 9 may record an order.
My lord,
Yes.
may I, my lord, item number, my lord, 15 and 16.
Yes.
I am praying for only, not today, and I am praying for your lordship's leave too, my lord, because I have oath, my lord, at 2 p.m. So I have to leave for, my lord, the Vidhan Sabha.
Oh.
Because of this matter only, my lord, I hear, but I mean, my lord,
16 as prayed list after the holidays.
15 and others matter, your lordship may pass, my lord, necessary order, my junior will be there.
All right, as one week after. 15 and 16. 10 to give the file 1 to 9. These
10 to
matters will be taken up after the holidays. Give a date.
And 10 to 14, my lordship may pass necessary order, my lord, may I take your lordship's leave, my lord?
Yes, consent order will be passed. Mr. Das is appearing or
My
somebody
lord,
else?
Mr.
You
Das
are
is appearing and my learned friend is also appearing.
No, no, for the
My lord, I
EC.
am appearing for, is for ECL, my lord, I am in 12, 13 and 14.
12,
Yes.
13 and, in
10,
10,
my,
11.
my,
You are appearing.
yes, 10 is my appeal, 11 is his appeal, my lord.
No, so who is appearing for ECL in 10?
Yes, yes.
In ECL, item number 1, 3, 4, 5, 6, 7.
Baba, ওটা বলছেন 10 and 11. 10, my lord, I am
10 and 11, you are appearing.
no,
Who is for the ACL in 10 and 11?
my learned friend. My learned friend.
10 and 11.
You are.
Yes.
All right, you can.
So should I hand over this written instruction? Yeah, 10 and 11 একটু মার্ক করে দিন 10 and 11 একটাই হবে
1 to 9 we will consider after the holidays. As the 1 to 9 record in order. The issue. to 14.
Dada. Dada.
Give sir your appearance. Give your appearance. Record the appearance. Record this. So that takes care of up to 9.
Yes, my lord.
Now 10 and 10 onwards.
My lord. Deeply obliged. Deeply obliged.
10 who is for the appellant?
Lordship, I am for the appellate, Your Lordship.
Where is that
Led by
instruction?
Mr. Parthogar.
Where is the instruction for the ECL instruction?
Item number 14, my lord, I hand over, Your Lordship.
You handed over. Come to the mic.
In these matters, I usually represent coal mines provident fund organizations. In the last occasion also, that is on 2nd April, last date, I have appeared. And I have given my appearance slip also to your Lordship's courts officer. But my name has been omitted.
Which date?
2nd April, the last date of this matter. I have given a separate appearance slip also.
Take down in that 1 to 9. You are
I appeared in item number 4.
Sir,
and
today's
10.
matter, in which cases you are appearing? You are appearing in all 1 to 9, all the matters. Then which matters? Please tell us. You're just saying the same thing again and again.
I appeared in item number 3 and item number 6 in today's list.
Today's item 3 and 6.
Item 4 and 6.
Make up your mind.
Item 4 and 6.
That is why your appearance is not being recorded.
Today, item 4 and
You
6.
are yourself not sure. You must be giving a slip in the wrong case. This is not the way.
Item number 4 and 6 in today's list. I have given my appearance slips also.
4 and 6 today.
Today. And on 2nd April, it was item number 4 and 10. Numbers are same. Case numbers are same. Item numbers are different.
In item 4 and 6.
Called 10 and 11. Worship called 10 and 11. Mr. Ghosh is in 10. I am for the respondent. Mr. Ghosh is for the appellant. In 11 is the cross appeal.
10 is one by itself.
One matter.
The file of 10.
I've handed over the instruction.
Give the file of 10, please.
10 or 11. No. Just everything short, man. It's okay. What else? 10 and 11.
Here also there is appeal and cross appeal.
My lord?
Here also there is appeal and cross appeal.
Lord, in-
10 is with 11. 10 is with 11.
Yes.
Yes.
10 is with 11 arising out of one writ.
Where is the instruction? Your instruction.
Lord, I have handed over. Hey, instruction to din. PCL is agreeable to grant MMCC without interest. And Mr. Ghosh has agreed.
Medical examination has been done.
Yes, we are. It's going on.
Please take down.
Twelve and 13, Mr. Manik Das is appearing, my lord.
Yes, my lord. 12 and 13, my lord. This matters, my lord.
Has to be.
Yes, my lord.
Identified.
My lord, two appeals, 12 is my appeal and 13 is the appeal of the writ petitioner, my lord. In both the matters, my lord, application for condonation of delay.
Is there any written instructions like we have in
My
the
lord,
earlier?
my lord, I take it on my own, my lord. I
All
have
right.
the instructions, but I, my lord, cannot. I
So
am
we
not
will
in
say
court,
in the
my lord,
same
right now.
terms. We will say in the same terms.
Yes, my lord. Only thing this applications for condonation of delay to be condoned, my lord, to be allowed, my lord.
Please
These
give
two
the condonation
applications.
application.
And one specification only, my lord, will be required because in this matters, my lord, the original petitioner died. She has been replaced, substituted by her daughter. So whatever the amount
Nagina
of
is the
NEPC comes,
daughter.
He is the daughter. Whatever the amount of MEC comes to be given to Nagina, my lord. Otherwise,
Yes.
the original writ petitioner. But only
Understood,
this much of
understood,
clarification.
understood, sir.
Grateful, my lord. Grateful, my lord.
We appreciate your intervention in the matter for getting it resolved this way.
Grateful, my lord.
Yes.
Grateful.
How many days of delay?
My lord, 59 days in my appeal, my lord. Item number 13, APOT 301 of 2025.
No, your appeal is item 12. not
Item
13.
12, my lord. Not
And-
13, my lord. I'm sorry, my lord.
Yes,
Then
and in 13 also there is
Yeah.
an application.
Yes, 13 also there is an application.
One is for condonation.
Yes, my lord. One is for condemnation.
Memorandum. 12, 12, 12. Huh. This is 301. Oh, this is 30. Where is the memorandum? Memorandum. Where is the report of delay? The fact say. It's 49, not 59.
Then, my lord, I have mistaken. Then, my lord, I thought
You,
it to be
you,
59.
you
my
have
lord.
said 59.
Yes, I have said 59.
There is a, and in 13, where is the application for condonation?
A1. DA1.
So first order in APOT 301. APOT 301. The application is for condonation of delay within bracket.
My lord, the video has been stopped, my lord.
See, we have directed,
Yes, my lord.
we have
Yes, my lord.
recorded the same instruction. We have said
Yes.
that you have expressed that now the payment is to be made to the legal heir. We have said you may
Yes.
take steps to make payment to her
Yes, my lord.
and
Yes, my lord.
expeditiously in accordance with law.
Okay. So, my lord, a time period, any time period, whether your lordship has pleased to fixed any time period for making the payment, we'll definitely try to make as early as possible, subject to compliance of the uh, other provisions, my lord. That
No, we have
will
said
be
in
wanting
accordance
the
with law, so whatever is required, they will do.
grateful, my lord. Grateful.
Expeditiously, we have said that we don't expect that
Grateful, my
now,
lord.
since such a stand has been taken, we don't expect
No,
that.
no, we will do it. We will do it as expeditiously as possible.
Yes.
Grateful, my lord. 12 and 13, my lord, in same terms.
Yes. 12,
Yes, ma'am.
13.
Yes, my lord.
Any other matter to be disposed of?
Now
with
14, now my lord, 14, my lord.
14.
14, yes. 14, my lord, the same, my lord. Stand taken
There
by
is
HDL,
no,
my
there
lord.
is there any condonation application here?
No, no, no condonation application here, my lord, right now.
And in both the orders, you write pending applications are accordingly disposed of.
14, my lord, the same order, my lord.
Same order which we have just passed in 14.
Yes.
Just leave the
Yes.
substitution thing. Everything else
Yes.
should remain the same.
Grateful, my lord.
Grateful, my lord. Grateful.
Yeah, matter item number 10.
On the last question, my lord, it has already argued regarding, my lord, our argument is concerned, my lord. You know that the marriage, second marriage and suspension, then termination, my lord, process. And this is a list of dates, my lord, regarding all the. আচ্ছা,
Have given this, sir.
yes.
There is any change?
No, ma'am.
Only Baba Mutt. That one. This is the Moni Baba Mutt one.
Yes, ma'am.
Yes.
That is, I think, the legend Netaji. Sometime it reflecting the paper. Moni Baba Ashram. That is Netaji Subhash Chandra Bose. That ashram.
Where is the judgment under appeal?
Judgment, my lord, 215 page.
256.
3. Yes, ma'am. 215.
You are for the writ petitioner. Hmm. Bring the second one.
The complaint has been taken into consideration by the wife, my lord, not other person.
What?
By the wife of the writ petitioner. He is the main complainant.
You. Where is the notes? I don't know my own notes.
Before the single bench. Page 125 also, matter. The other allegation also there. Under section 498A, 506 IPC. 3 and 4 DPI.
पेपर बुक में नहीं पेपर बुक में you will have to refresh. You will have to refresh. We don't remember. We just remember that is an allegation of second marriage.
Yes. But the ashram malad, ashram
And
register reflected
that the somebody from the Moni Baba Mutt has appeared. He has appeared in the proceeding.
Munimamba ashram is there. Malad. Ashram.
So somebody from the Mutt appeared or nobody appeared?
Mutt is appeared.
And he submitted the register, copy of the
Register,
register. No?
Register photocopy. Malad.
We'll have to. You will have to refresh properly. Have to refresh.
Next proceeding.
Huh?
Oh yes, yes. Oh yes.
Yes, it is very unique. Maybe it is in the chamber, I don't know.
You should note it down all the arguments.
Yes, that is not here. Yeah.
Then argument.
Check in the second.
Check.
I can understand my notes. Nobody can.
I remember that paper maybe in the file. Your worship just kept it up. I take a check code.
Yes. No, we'll take it up on 11/6. You give your appearances. We have recorded an order. Yes.
Do we synopsis the case?
You have already given. You have already given.
11/6 for order, Malad.
No, sir.
Again. Yes.
Just take us through the 2-3 documents which we had seen. Yes.
Develop.
Traffic. It is finishes.
What?
Finishes time. Okay. It doesn't miss more than it's 36. 7. Not today. 9. 40. 41. 43. 4 and 45. That means yeah. Also running. Okay. That one today we have fixed. Mr. SM